All right, here we go. We get to talk about future interests, present possessory estates, and future interests in the rule against perpetuities. Before that, let's talk about trust modification and early termination will really depend on whether or not we've got a revocable or irrevocable trust. Keeping in mind that any type of inter vivos arrangement must be modified or changed during lifetime. Quite often you'll see someone try to change something by will, and that won't work because an inter vivos arrangement must be changed inter vivosly during lifetime, and a will speaks at death. So those two are a disconnect. The irrevocable trust has a three-part test that must be satisfied. All beneficiaries and interests must consent, purpose, and intent. Purpose carried out and intent followed. All right, so remember we've talked about the requirements of a trust, and the one that we're going to be focusing on in terms of the rule against perpetuities is the beneficiary, because a trust can be established for multiple beneficiaries. From Moss v. Axford, we know all that we need is that a court, using extrinsic evidence, simply needs to ascertain who the beneficiary is. We will begin to look at classes who are capable of increasing, who are not fully ascertained at the time of creation. We have what's called a class closing rule. When one member of that class can demand distribution, the class closes. We need to understand the various future interests, because if a future interest holder dies, what happens to their future interest? Does it go through their estate or does it disappear? All right, so every trust that's set up for multiple generations has both present possessory estate holders and future interests. A present possessory estate holder is like a life estate. They have the right to the immediate use and enjoyment of the property right here and now. Future estate holders, their use and enjoyment is postponed to some time in the future. And it's those future estate holders, certain future estate holders and third parties, that we will examine for determining whether or not the settler has gone too far by violating the rule against perpetuities. It's a very good idea to take a quick look at the table 5.1 in the appendix to understand that certain present possessory estates are wed to, for life, certain future interests. So you've got to identify the present possessory estate first before you can identify the future interests. All right, so we've talked about there being multiple levels, or could be multiple levels of future interest. Only one present possessory estate holder, but multiple future interests. We will mostly focus on a life estate. A life estate is followed by some type of remainder. There are 4 types of potential remainders: vested, contingent, vested remainder subject to open, and vested remainder subject to divestment. It is the executory interest, that is the cutting short interest, that needs to be examined in terms of RAP. All right, so taking a look at the most simplest to A for life, then to B. Life A has a life estate, RAP non-applicable. Then to B, we know exactly who B is. He's a named, or she is a named individual. So that is a vested remainder. If B predeceases A, the future interest, that vested remainder will go through B's estate. If B had a will, it will go to the will beneficiaries. If B did not have a will, it will go to B's heirs. They will hold that future interest. But it is vested and RAP non-applicable for a vested remainder. How about to A for life, then to B if surviving? The if surviving language is the contingent. We don't know if B is going to survive A's life estate. But when will we know whether or not B's interest vests or fails? Either at the death of A or B. If B dies first, we know it failed. If B dies second, we know it vests. The thing to think about with contingent remainders, if the settlor has not designated what happens in the event that the contingency fails, you have a reversion, a silent reversion, because the settlor by default has retained something by not giving it away. So in this case, this future interest, this contingent remainder is in B is valid because we will know one way or another during a measuring life of either A or B whether or not B's interest vests or fails within a life in being plus 21 years. Forget the 21 years for now. And that's all that we need to do in terms of WRAP. How about a vested remainder subject to open? How do I identify that? I'm looking for a class whose parent is still alive and capable of producing more members of that class, but at least one member is born. If no members are born, then it's a contingent remainder because of the possibility that nobody may be born. If one member is born, that person will take even if they don't survive, but it's subject to open. When can one member demand distribution is when that class will close. Here, no one can demand a distribution until A's death because A has a life estate. This is valid for purposes of WRAP. We can use A as the measuring life. At that point, all of the members will be either ascertained or not, and thus it's valid for purposes of WRAP. The cutting short, look for language, but if language. We have to look to see whether or not C, not B, but C will vest or fail within a life in being plus 21 years. Now, because this does not follow the natural termination of a life estate, C has the only other type of future interest in a third party. It's not a remainder, it must be an executory interest. This is valid for purposes of WRAP because we have named people. We can use A, B, and or C. We will know if B is alive at A's death, and we can use B as a measuring life for determining that C's interest satisfies WRAP. Now think about WRAP and what it is. It is a limitation imposed on dead hand control. We did not want property interests being controlled by the dead. So they came up with this rule that says you can control it for so long. For someone who is a life in being, guaranteed to be alive at the creation, plus 21 years, which was to account for that life in being's person's children reaching the age of majority. Now, it doesn't mean that that's how it has to turn out, but that's how they came up with the WRAP period of a life in being plus 21 years. And it imposes a limitation on how long someone can control property from the dead, and thus that's where it gets its name, dead hand control. Have to be familiar with the common law rule. No interest is good unless it must vest or fail within a life in being plus 21 years. Well, let's break it down a little bit. It's not no interest. It's certain future interest. The WRAP applies only to contingent remainders, vested remainders subject to open, and executory interests. It doesn't have to always vest and thus possess. It can vest or fail. It can vest or fail when? Within a life in being. That is where you're getting your bang for your buck. That is the life in being you need to look for. Don't get hung up in the 21 years. Find a measuring life, or if you're lucky enough, a whole group measuring lives, an entire class that has to be fully ascertained at the creation. Then look at the 21 years. Keep in mind there are some codifications to RAP. We have the Uniform Statutory RAP, which is a 90-year. Maryland follows the wait and see, but keep in mind you can also create certain interests and trust in perpetuities in Maryland by including certain language and allowing the trustee to buy and sell. So Maryland, along with many jurisdictions, allows a trust to exist in perpetuities. There is a roadmap. Follow it. When were the present estate and future interests created? Identify them at that time. Thirdly, did you identify any interests that warrant a RAP analysis? If not, state RAP non-applicable. Only look at RAP for contingent remainders, vested remainders subject to open or executory interests. And what happens if there is a RAP violation? Remembering that only applies to certain future interests in third parties, so have you identified one of those is important.